This session, after we determined that we were unable to really finance a change in 0.15 to 0.08 in the ignition interlock, I sort of backed up and picked up a series of housekeeping bills to clarify and expand the DUI law, and in particular, the one on implied consent says if you refuse implied consent, you will be ignition interlocked, and that essentially empowers the judges to use the ignition interlock, does not require them to do it. Next session, what I'd really like to do is successfully move 0.15 to 0.08 so that every offender who violates our DUI law, even at 0.08, would be eligible, if the court deems it appropriate, for 0.08 application of the ignition interlock. Ultimately, the ultimate goal here in the state of Tennessee, from my perspective as the guy that's carrying the legislation on the ignition interlock, would be to empower the courts by way of training and education through their conferences to get the judges to impose ignition interlock on first-time offenders prior to being adjudicated. So if you come in and you've tested a 0.08 as a condition of bail, you will be placed on an ignition interlock or some other electronic device that gives the court and the public some assurance that you won't be driving drunk and getting a second offense. The question of how do we keep repeat offenders off the street, ultimately this comes down to a point of personal responsibility. And if these individuals really appreciated personal responsibility, they wouldn't be drinking and driving to begin with. So the only way to keep these type people off the streets is to tie them up either in the judicial process, meaning they stay in jail, which costs us $60 a day per person, which draws with it that big fiscal note the taxpayer has to carry the weight, or a combination of electronic devices that detect alcohol and communicate either to the car or communicate by way of a cell phone to a probation officer to go pick somebody up if they're drinking. So as technology has improved, we certainly have more options. One of the problems, though, that we got to look at very carefully is the constitutional rights and protections against on behalf of the accused. So the Constitution is a double-edged sword there, and you don't want to get people to draw a huge punishment prior to being adjudicated. Maybe another way to look at this is to get the drug court or the alcohol courts to adjudicate quicker, for the judges to deny delays by defense attorneys, and get those people in there quickly with perhaps incentives that, as opposed to jail, they go to treatment programs. There are treatment programs right now that are available and they have to pay for. So there's a combination of things. But as we as elected officials and our society work together, over the next decade or generation, with technology enhancements, we'll begin to find more attractive ways, more cost-effective ways to handle this disease.